shocking details emerge from a hearing in the case against two suspects accused of murdering a University of Wisconsin couple.
The court, unlike at a trial, must look at the evidence in the light most favorable to the state at this proceeding.
Dr. Beth Potter and her husband, Robin Carre, were found in a ditch near the campus arboretum. Both had been shot in the head, execution style.
He was wearing a pair of boxers. That was it. She had been wearing pajamas and socks, but no shoes.
Detectives questioned the couple's adopted daughter, Miriam. Her story led them to zero in on her boyfriend, Carre Sanford, and his alleged partner in crime, Elijah LaRue.
Detective Burmeiser, during your contact with Ms. Potter Carre, did you and Detective Grand take custody of a cell phone that had been in her possession?
Yes, we did.
While detectives have evidence that appears to implicate all three in the couple's murder, only Sanford and LaRue are charged.
He overheard a conversation between Miriam Potter Carre and Carre Sanford.
Investigators uncovered a witness, a high school classmate who told police he overheard Miriam plotting with her boyfriend.
He stated that he had been in a ceramics class at West High School. They were talking about robbing her parents because they were rich and that they had bands of money.
But Sanford's lawyer tries to limit the damage.
When the victims in this case were discovered, it's my understanding that Dr. Potter was still alive, is that correct?
Correct.
She was pronounced dead, my understanding is approximately an hour and a half after her discovery?
Correct.
During that period of time, she did not implicate Mr. Sanford in her attack, is that accurate?
Correct.
While defense attorneys suggest there is no physical evidence tying their clients to the murders, cell phone records tell an incriminating story.
At approximately 10:57 p.m., where did the GPS data from Mr. LaRue's phone suggest he was located?
It plotted near the intersection of North Winkler Drive and Vilas Park Drive.
Could you describe for the court how that intersection would relate to the area approximately and where the bodies were found?
That would be basically the entrance of the UW Arboretum.
Just as cell phone tracking data puts LaRue at the crime scene the night before the bodies are discovered, surveillance video picks up this white van.
The victims had loaned their vehicle to Miriam Potter Carre and Carre Sanford for use while they were living at the Airbnb.
Defense attorneys take turns attacking the evidence.
We have no GPS suggestion that he was at any relevant locations.
There was zero evidence presented that he was the shooter of these victims. There was no evidence at all that he knew that there was going to be a shooting.
We have no evidence that ties him to the shell casings or any gun at all.
But there's enough evidence to convince the judge to let a jury make the ultimate decision.
This court does find that for both Mr. Sanford and Mr. LaRue, probable cause has been shown that a felony has been committed and that each defendant probably committed it as a party to a crime.
All right, so these cases are going forward, but the real question is, what role will the daughter, Mimi, play in all of this? Will she show up in the courtroom? Will she be subpoenaed? And who will subpoena her? Will it be the prosecution or defense? And if she gets up on the witness stand, what would she say? Because I know one thing, the jury is going to want to hear from her. She's the one person who is in the middle of all of this. Joining us now from Milwaukee, Wisconsin, criminal defense attorney Jason Luzak back with us. Jason, great to see you. Let's talk about the daughter, Mimi. I mean, there is no other person that is more in the middle of all of this than she is. And I'm not saying she's guilty of anything, but she is the girlfriend of one of the defendants. She is the daughter of the victims. I mean, she is connected more than anyone to this case. And if I'm sitting in that jury box, I want to hear from her.
Oh, yeah, Vinny, you're definitely going to hear from her. And I guess the real question is, there's a specific paragraph, basically a number of paragraphs in the criminal complaint that are devoted to talking about how she made untruthful statements to the police. in relation to this investigation. So to me, that kind of shows the prosecution's hand here, that they're going to have to use her, and they're going to probably give her some consideration for testifying, because I think that's the only reason they lay that out. I mean, they basically lay out all the cards in the criminal complaint here.
So what you're saying is that she's in trouble because she allegedly lied to police. Hold that over her head, whether she is or is not in any way connected to the murder of her own parents, but use it to get the information that they're going to need to tie these defendants directly to the murder.
Yeah, absolutely. So they have a lot of pieces of evidence. I mean, the boyfriend's attorney has made mention a couple of times that, we don't know what transpired, or we don't know how this got to this point. Well, I mean, to me, that's kind of a tell as well, that, you're basically going to have the boyfriend probably saying that things escalated in a way that was not anticipated. But to me, that probably doesn't matter that much as far as a defense goes, because you've got these individuals placed with some amount of GPS according to the criminal complaint. You've got a lot of text messages, and then you also have somebody who came forward and basically said that the boyfriend had confessed to the shooting. So, I mean, this is a tough defense case here, but I think that the missing link here is definitely what the daughter has to say, and I think she's being held back.
Now, there's going to be separate trials for these two defendants. Is another part of the trial, I'm going to point the finger at the person who's not here. So if I'm on trial, it's the other guy, and when the other guy's on trial, no, it's that guy over there.
Yeah, I think that's going to be the strategy, but I don't think it's going to work because they're charged as party to a crime. So, if they're if they're highly connected to each other, I mean, they basically sound like they have to place each other close to where this murder occurred. I don't think that's in dispute. And if they're pointing fingers at each other, regardless of if this was a robbery gone awry, there's still some serious issues. And I think a jury is going to have a lot of problems getting over that fact.
Let me ask you this. Let's say that there is no deal on the table. Prosecutors aren't offering anything to the daughter, Mimi, but she is subpoenaed by one side or the other and gets up on the witness stand. Is she entitled to say, I take the fifth, I'm not saying anything? What is the basis? What has to be the foundation in order to say, I take the fifth?
Well, it can't really be gone into that much. So, I mean, she certainly, if I were representing her, I would advise her to take the fifth. In Wisconsin, that's something that would happen outside the presence of the jury. And, essentially would be something that they wouldn't be able to hear. But if you have a savvy prosecutor, you could offer immunity even in the midst of trial. And that would likely be something that would occur. But my sense is that given how much they went into what she said in the untruthful statements, I think that if I were reading that and I were her, I would be concerned about my own criminal liability. I would be concerned about assisting in the prosecution in some way and looking to get to lessen my liability.
Yeah, unbelievable case. Cases, actually, at this point. Jason Lusak, always great to have your insight. Thank you.
Thanks, Vinny.
All right, we are tracking these two trials. Let's take a look. We got some dates here for Carre Sanford. A motion hearing on March 1st. No trial date yet. We may find out on the 1st. And then April 6th, the motion hearing for Elijah LaRue. Again, no trial date, but at that motion hearing, we may very well get that date. When we